Unmuted. Muted.
Welcome to the webinar, Pretrial Motions, Admitting and Excluding Evidence in the Prosecution of Sexual Abuse and Confinement. Today's program is sponsored by AEquitas, the Prosecutors' Resource on Violence Against Women, and the National PREA Resource Center. We will begin the webinar in 5 minutes. Please stay on line. If you experience any technical difficulties, please contact iLink Technical Support at 1-800-799-4510. Again, that number is 800-799-4510. Hello again, and welcome to the webinar, Pretrial Motions, Admitting and Excluding Evidence in the Prosecution of Sexual Abuse and Confinement. Today's webinar will begin in 2 minutes, so please stay on the line. If you experience any technical difficulties, please contact iLink Technical Support at 1-800-799-4510. Again, that number is 1-800-799-4510. Test. Good afternoon, everyone, and welcome to the webinar, Pretrial Motions, Admitting and Excluding Evidence in the Prosecution of Sexual Abuse and Confinement. My name is Christina Matthews, and I'm the Communication and Operations Manager for AEquitas, the Prosecutors' Resource on Violence Against Women, and I will be moderating today's webinar. Before we begin the substantive portion of our program, I would like to provide a brief overview of our iLink webinar service. If you have speakers for your computer and you're able to utilize Internet audio indicated by the headphones icon beside your name on the attendee list, please do not call in as well unless you experience difficulty with your Internet audio and you would prefer to call in. For those of you joining the webinar via conference call, you should have been notified upon entry that your line was muted and audio chat had been disabled. The iLink hand raise option is located on the toolbar above the photo of currently myself or whomever may be holding the floor at the time, and it can be used to indicate applause, a need for assistance, or the fact that you have stepped away. I'd like everyone to take a moment and locate the hand raise option. By a quick show of hands, how many of you are using Internet audio today? It looks like several of you have the speaker beside your name, but only one of you is raising your hand. I want to make sure everyone has a few minutes to find that option. Thank you, Joseph, for raising your hand. Anyone else, if you just want to go ahead and clap to show your status, maybe applaud, show a thumbs up or a thumbs down. Thank you, Richard, also for raising your hand. Okay, great. We at least have 3 of you that have found the hand raise option. The iLink feedback option is located on the left-hand side of your screen below the list of attendee names that sits just below my photograph. And we'll be using the feedback option throughout today's webinar to respond to questions posed to you all by our facilitator and by myself. My first question to you all is whether or not you've previously attended an iLink webinar. And you're going to have the option to select yes or no. If you have previously attended, I would just ask that you select yes, and if you have not, that you would select no. I'm going to give you all a few seconds to go ahead and get those answers in for me. Okay, and a few of you have gone ahead and responded. It looks like the majority of you that have responded have previously attended an iLink webinar, so that's good. And finally, the iLink private chat option is located below the feedback option that we just used, and this is enabled for you all to communicate directly with myself and with each other. Substantive questions can be submitted to me using the chat feature during the webinar, and I will relay your questions to our presenter. Additionally, our presenter may pose open-ended questions during today's presentation, and if you're interested in responding, we ask that you do so by private chatting your responses to me. Also, and finally, if you would like to enlarge the content screen in iLink, you can minimize the chat window by clicking on the arrow box in the left-hand corner. If you would like to reopen the chat window, you can just click on that same box again. And last but not least, if you experience any technical difficulties during the webinar, please contact iLink Technical Support at 1-800-799-4510. Again, that number is 1-800-799-4510. Today's webinar, Pretrial Motions Admitting and Excluding Evidence in the Prosecution of Sexual Abuse and Confinement, is hosted by AEquitas, the Prosecutors' Resource on Violence Against Women, and the National PREA Resource Center through a cooperative agreement between the National Council on Crime and Delinquency and the U.S. Department of Justice, Office of Justice Programs, Bureau of Justice Assistance. Written materials, including a copy of the PowerPoint presentation, along with the presenter's bio, will be emailed to you all after the presentation and posted on the National PREA Resource Center's website. The National PREA Resource Center, or PRC, was established through a cooperative agreement between the Bureau of Justice Assistance and the National Council on Crime and Delinquency, or NCCD. The mission of the PRC is to assist adult prisons and jails, juvenile facilities, lockups, and community corrections and tribal facilities in their efforts to eliminate sexual abuse by increasing their capacity for prevention, detection, monitoring, responding to incidents, and services to victims and families. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff, including several career prosecutors, conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars just like this, provide individual experts to jurisdictions and organizations, and publish monographs, articles, and other resources on topics relevant to the prosecution of violence against women. Today's webinar was developed to help prosecutors and allied justice system professionals more effectively anticipate issues and evidence that need to be addressed prior to trial, file and argue pretrial motions, and respond to defense motions. Experienced prosecutors know that pretrial motions play a critical role in the outcome of sexual abuse cases, and this webinar will underscore that fact. Today's presenter will be AEquitas Attorney Advisor Viktoria Kristiansson, whose image is now on your screen and unfortunately will not show up as the floor holder. You will see a gray silhouette, but that's Vicki's smiling face for you all. Prior to joining AEquitas, Vicki served as a Deputy Attorney General and Special Assistant to the Attorney General of New Jersey. She also served as a Senior Attorney for the National Center for the Prosecution of Violence Against Women and as an Assistant District Attorney in Philadelphia, Pennsylvania. Now I'd like to turn the floor over to Vicki so that she can begin the substantive portion of today's webinar. Vicki?
Good afternoon, everyone. Thank you so much for joining us. Today we're going to utilize in the webinar a case file, a fact pattern, which is really designed to get you thinking about pretrial motions you have to file in cases in order to even get to trial, and then in order to be able to admit and exclude the right evidence. So at the conclusion, hopefully you'll be better able to anticipate issues and evidence that need to be addressed prior to trial, file and argue pretrial motions, and respond to defense motions. I mean, for all of us, how many times have we been in the middle of trial only to have the defense seek to admit something, some evidence that your jurisdiction's case law clearly says is irrelevant or otherwise inadmissible? We have all been there, and frankly, we shouldn't be there as often as we are, because particularly in sex abuse cases where so much of our evidence rests on victim credibility, we need to be extra diligent about excluding irrelevant and misleading information. And just as importantly, we need to do our part to file motions on time to admit crucial evidence in our case in chief. Throughout the webinar, we encourage you to submit any prosecution-related questions and comments or questions about PREA and the standards, the latter of which will be answered by Tara Graham, who's the Senior Program Specialist at the PREA Resource Center. So our first question really, why are we preparing and why are we filing pretrial motions? For all the reasons that are listed on this slide. We need to keep our victims safe, prevent intimidation, properly prepare our cases for trial, shield victims from harassment, invasion of privacy, and unfair prejudice, and very importantly, expose defendants for who and what they really are. We prepare them because we know if we don't, irrelevant evidence will come in at trial, and this is especially true in sexual abuse cases. Also, when we take the time to painstakingly comb through the specific details of our case, we can often better anticipate defense motions and strategies, and we can get a window into the defense. You know, is this going to be a consent defense, a misidentification defense, or a we're going to attack the victim kind of defense? You know, the victim is fabricating the whole thing due to what? And when we're talking about victims who are incarcerated, a possible defense is going to be really attacking the victim, attacking credibility, and coming up with a motive. This victim just wanted to transfer, or this victim just wanted to get away from X. So really preparing these motions and filing them can provide us with information on defense trial arguments and strategy. Sexual abuse, we're going to use that term throughout this webinar because the PREA standards, the Prison Rape Elimination Act standards, use this term to refer to most unlawful sexual touching and penetration. So here, it refers to contact between the penis and the vulva or anus, contact between the mouth and the penis, vulva, or anus, penetration of the anal or genital opening, and any other intentional touching, either directly or through the clothing of the genitalia, anus, groin, breast, inner thigh, or the buttocks of any person that is unrelated to official duties or where the staff member, contractor, or volunteer. So note, everybody, PREA applies to contractors and volunteers, has the intent to abuse, arouse, or gratify sexual desire. This slide contains a brief synopsis of the passage of PREA and the standards. And just note that it's taken a decade since the passage to get to the standards implementation and thus the emphasis on training for all of us so that we can better handle these cases. Let's jump right into our case today. On Monday, February 18th, 2013, Carbon County Special Victims Unit Detective Herbert Rackout generated the following report. The previous Friday, February 15th, James Minor, age 19, an inmate in the Adams County Jail, attended an English class in preparation for his GED. At approximately 11 a.m. when the class was over, Minor relayed the following to his instructor, Gloria Velasquez. When Minor was ages 15 through 17, he was housed as a delinquent in the Carbon Juvenile Detention Center. About 2 months after his arrival in the detention center, he was sexually abused by Staff Officer Mary Bennett. Mary Bennett would remove Minor from classes or other activities and take him to empty rooms or closets where she would put a condom on his penis and force Minor to insert his penis into her vagina. She also put her mouth on Minor's penis and sucked on his penis. This occurred several times per week, sometimes twice per day for approximately 1 year. After 1 year, it still occurred but less frequently. Minor believes that at that point, Bennett may have done the same thing to another juvenile or perhaps 2 other juveniles in that same facility. So what do we know about particularly the victimization of our youth? And what do we know about offenders who are staff members? Well, 12% of youth in juvenile facilities reported experiencing 1 or more incidents of sexual victimization by other youth or by facility staff. And of those 12%, so think about this, this is 12 out of every 100 minors who are going into a facility. 2.6% of the perpetrators were other youth, and 10.3% were staff. 95% of all youth reporting staff sexual misconduct reported being victimized by female staff. I don't know about all of you, but those of us who are prosecutors who usually handle sexual assault cases, I know that I was surprised when I saw that statistic, and I thought that it was important in terms of the processing of these cases and really understanding the reality of what our youth are experiencing and what offenders we should be looking out for. Obviously anyone, but we need to think about this percentage of women, which we don't often see. We certainly don't see percentages this high in terms of all offenders outside of confinement. And just, if you have a minute, have the majority of your rape cases, at least in general, in terms of what you handle, do they involve juvenile victims or do they involve adult victims? Can you just take a couple seconds and respond if the majority of your case involves, if the majority of your cases involve juvenile victims? If the answer is yes, can you let us know? you can just do the hand raise if the answer is yes.
I've also gone ahead and put up the feedback option so that if you all would like to answer yes or no to the question Vicki just posed, you can do so using the feedback option underneath your name.
So a few of you responded, and it seems like half and half. So pretrial motions, these are really our very broad pretrial motion categories, and a lot of the motions that we're going to discuss today and we're going to utilize in our everyday lives in terms of these cases, of course, fall under two or more of these categories. Victim protection, offender-focused pretrial motions, motions that focus on records, and motions that focus on trial itself. Question for you guys. Have you filed a pretrial motion in a sexual abuse case that is similar to the case against Mary Bennett? And by similar, I mean a case where the defendant had a duty of care over the victim in a professional capacity, a teacher, or even a non-professional. If you've handled a case involving a parent or guardian who sexually abused a child in his or her care. Okay, so it seems as if the majority of you perhaps have not had a lot of experiences with pretrial motions in these cases, which is good because then we expect a lot of questions from you throughout the webinar, and we'd be happy to answer them during the webinar and, of course, after the webinar. So our first category are victim protection motions. What do we mean when we talk about victim protection motions? Well, really we're talking about a range of things. We're talking about everything from a stay-away order to talking about increasing bail and other things related to that. In terms of protective orders, it's really important for us to know what we are really dealing with in terms of the facts of this case and in terms of the history of Mary Bennett. So we want to do what we can to talk to our investigators who are handling this case, who have been in the confinement facility. Of course, we want to try to, as prosecutors, visit it ourselves. We want to communicate with other corrections staff and other leaders to determine what has already been done and what, if anything, can be done in terms of Mary Bennett. As far as a separation order, you may not have to seek a traditional one, as our victim is an inmate and Mary Bennett is not an inmate, and by the time this case comes to our attention, she should, at a minimum, not be in a facility anymore. However, you want to file a separation order just in case, and you want to specify that the separation be in effect at all times. We've already delivered one PREA-related webinar, and during that webinar we talked about the importance of separation all times. And when you're filing these orders, you want to include that the separation necessarily must include during transport to and from the courthouse and while the victim and the offender are in the courthouse. And that's extra important because we certainly do not want there to be intimidation while the victim is on the way to court, and certainly not in the building itself. And this is something that we as prosecutors sort of tend to take for granted. Well, of course they're going to be separated. You know, they're not going to be put together. And in fact, we've heard time and time again that there have been times when a victim and a defendant were even taken to court together in the same van, that they were housed in the same cell while awaiting a hearing in a courthouse. And in fact, there's a case out of North Carolina called State v. Weathers. If anybody wants to cite, you can certainly contact us afterwards, where in fact one of the acts of intimidation occurred during transport to the courthouse, and then in the courthouse itself. So not only do we want to focus on separating the victim and the defendant at all times, but in these cases, particularly involving an offender who is a staff member, we want to try to get facts related to any possible intimidation or retaliation from the defendant's associates. You know, even though Mary Bennett is not currently or was not currently working in the facility where James Minor was housed at the time that he reported sexual abuse, you never know if there's going to be intimidation or retaliation. So we want to consider other staff or inmates who may have threatened James as a result of him making this report, filing a report. Consider whether James may be in danger in his current placement due to the report. And if Mary Bennett is in custody, we want to, of course, motion for her bail to be as high as possible because, after all, she is charged to care for those who are part of our criminal justice system. Not only did she commit this horrific act against a juvenile, but at the same time, the public counted on her, was paying for her to work for society, and she betrayed our trust as well as her professional duties. Here are some of the shields, and we've put them out in two categories: the rules of evidence that could be applicable to determining shields, and then also the motions in limine. So let's talk about the various shields that rules of evidence and statutes and case law provide. In terms of excluding irrelevant behavior, this includes behavior in and out of incarceration as far as James Minor goes. So we're going to seek to exclude irrelevant evidence related to the victim's prison history. And in order to do that, we want to take the extra step of getting as many files as we can and redacting this information when appropriate. We don't want to be passive about this and wait for the defense to get these things and file motions and then us have to respond. So we want to get the files, redact, and clarify, of course, that we're going to notify the court that we've been redacting, and if your jurisdiction requires it, you would have an in-camera hearing regarding that, and then you're going to litigate that. We want to exclude criminal history if the evidence is not related to the sexual abuse victimization. So that could be evidence related to the victim's pending case or another irrelevant criminal case via either an arrest or any other part of its history. A motion to exclude the victim's irrelevant character evidence. And again, this is another example of these going a long way toward preventing harassment of the victim and precluding victim bashing both before and during the trial. As far as privilege, always file. Do not assume that because your jurisdiction protects certain communications and certain relationships from being disclosed in court, that the defense won't try to get in this information anyway, and certainly don't assume that the judge is going to be very familiar with privilege law. Always file. Rape shield is covered by Rule of Evidence 412, and we're going to talk about this a little more in a minute, but essentially, rape shield governs the victim's sexual behavior or predisposition, and the public policy behind these laws is to protect victims from embarrassing public fishing expeditions into their past lives, into their past sexual conduct. There has to, at a minimum, be a preliminary showing that the evidence would be relevant to some issue in the pending case. And really, Rape Shield exists because people have become educated over time, and we have started to understand that victims of sexual assault should not be subjected to emotional abuse or psychological abuse in court as the price of their cooperation in a sexual assault case. So another question for you. Does the prosecution in your jurisdiction, if you know, does the prosecution have a legal basis to file a motion to exclude the crime that led to James Minor's adjudication of delinquency? So in other words, the reason that he was in the detention facility at the time that Mary Bennett sexually abused him. And you can guess. If you don't know, what do you think would happen in your jurisdiction? or have you heard of things that have happened in your jurisdiction? So please use that feedback option and let us know.
Okay, it looks like the vast majority of you that have responded have indicated yes. There are a few no's. So, Vicki, can you tell us what the answer to that question is?
So really, it depends. I mean, you would want to certainly, when you think about the vast majority of jurisdictions law, the answer would probably be yes. I mean, of course, you'd want to file it. Yes, you would. But on what grounds and what does your jurisdiction's law say? I mean, you would certainly argue relevance. So you'd argue your rules of evidence 401 and 403. You'd maybe argue 404 because you'd argue that it's not admissible regarding motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. You could argue 608, that the crime for which he was incarcerated is not one that has anything to do with character for truthfulness or untruthfulness. And other things to consider are, impeachment by evidence of criminal conviction 609, but that too is subject to relevance under 403. So you've got to do the balancing test. But the other thing to consider is, most of us are leaning towards yes. We would absolutely file the motion to exclude the crime. But we want to take a minute, of course, as we're evaluating our evidence and pause and consider whether there are any strategic reasons that we would have for admitting evidence that might normally be excluded permissibly under our law. And think about what that balancing test would be for you in terms of perhaps indicating that his underlying conviction provided some kind of victim selection process for Mary Bennett. In other words, maybe she targeted certain kinds of criminals. And when I mean that, she viewed kids as this is one category of criminal, this is one category. Maybe she targeted kids who had issues with narcotics. Maybe she targeted kids who had issues with gangs. Maybe she looked into a kid's family history. Maybe she looked at kids who were hanging out with other kinds of kids. So in terms of strategy, there might be a reason that we would want to include the conviction that led to his original adjudication of delinquency. But regardless, if it took you some time to figure that out, just so that you would have the motion filed, you certainly could file it. So getting back to our case, James Minor was arrested on December 25th, 2012 for possession with intent to deliver heroin. He is still now being held on a probation violation as he was still being supervised by juvenile authorities. So he gets arrested for possession with intent to deliver heroin, and he's in custody because of that case, but he also has a violation of probation detainer that was lodged by juvenile authorities. So now we know why James Minor was back in custody, why he was taking a GED class, after which he disclosed the sexual assault. So the question for you is, if the prosecution files a motion to exclude that possession with intent to deliver, to exclude the crime for which Minor is currently being held, will that motion be granted? So use feedback and let us know.
Okay, everyone, I've expanded the feedback option for you all to type in your responses. We're already getting a few. We'll wait just a few more moments to try to try to engage the rest of you. And also, I want to remind everyone that if you have any questions related to anything that Vicki's touching on that you would like to pose questions for, you're welcome to submit those questions to me via private chat, which is just below that feedback window you're using right now. And we'll get those out to Vicki so that we can make sure your questions are answered. All right, we're still getting a few more responses, but for the most part, it looks like you're split on the issue, with just a few more of you indicating that, yes, the prosecution or the motion would be granted if the prosecution filed it in this case. Vicki?
And really, this goes back to the laws of your jurisdiction and that balancing test that we always have to do under 403. So let's talk a little bit about Rape Shield. Under Rape Shield, generally inadmissible is evidence that is offered to prove that a victim engaged in other sexual behavior, and evidence offered to provide a victim's sexual predisposition, or at least, of course, that's what the defense is arguing. So we should ask here, who is shielded? Certainly our victim in the case, but when we think about the facts of our case, what did we find out that occurred toward the end of Mary Bennett's abuse of James Minor? That he believed there were one or two other possible victims. And so what's important for us to recall and think about as prosecutors is that Rape Shield applies to any victim, including our 404B victims, our other act evidence victims, which I'll talk about in a little bit. But under many states' Rape Shield laws, remember that the evidence of the prior sexual conduct is inadmissible to show consent or credibility. So Rape Shield doesn't act as an absolute bar to the admission at trial of evidence regarding the victim's past sexual conduct. There are exceptions, but the case law and the rules have done a good job of keeping it out. However, this is a reminder of why we must always file the motion. Do not wait for defense to bring up something and object that can't come in under Rape Shield. We must file the motion. Here's another question for you. So the defendant files a pretrial motion to introduce a prior consensual sexual contact, so with someone else, in other words, another inmate, that was prohibited by the rules of the confinement facility as evidence that engaging in sexual behavior that is against the rules is a pattern of conduct for the victim. Will this motion be granted? What is the most likely result here? Will it most likely be granted, or will it most likely not be granted?
Okay, and the feedback option has been opened again for you all's responses, and this time they actually started coming in before Vicki even finished the questions. So we know that you all are engaged and that you're interested in this question particularly, and the overwhelming responses in this case are no, that motion will not be filed. There are a few of you who think that it would be, but for the majority of you, the answer to that question is no. I'll turn it back over to you, Vicki.
So for the most part, the answer would likely be no, but we certainly have heard of some situations where it would. And so particularly for those few who answered yes, if you want to private chat something to Christina, maybe perhaps a case where something similar occurred and the defense motion was granted, or some examples like that, and Christina can anonymously share the comment with the group, that would be great, because we're always looking to see those outliers. But We have to remember that defendants are often going to, remember guys, what is the consent? I mean, what is the defense in these cases? No matter what the defense is, no matter whether in a sexual assault case the defense is consent or it didn't happen or the victim is fabricating the whole thing, regardless, what are we unfortunately seeing happens time and time again, and that is that the defense strategy is to take the focus off of the defendant and attack the victim's credibility, and spend as much time during the trial trying to bring out quote-unquote bad facts about the victim. So defendants will often attempt to admit evidence around the rape shield law by arguing that the prior sexual conduct of the victim fits a pattern of behavior similar to the charge offense to prove consent. So, we've talked about that case law has generally held that the pattern must be distinctive, and the case law has said that it has to be distinctive to the extent that I'll give you a quote, so closely resembles the defendant's version of the encounter that it tends to prove that the complainant consented to the acts charged or behaved in such a manner as to lead the defendant to believe that the complainant consented, end quote. And there is case law in several jurisdictions that supports that holding. But in our case, it's very important for us to remember that any of this would most likely be completely irrelevant. And that is because under PREA, there is no such thing as a consensual sexual contact between staff and an inmate. And remember, under PREA, the definition of staff includes contractors, includes volunteers. So this argument would be completely irrelevant because an inmate cannot consent to any kind of sexual contact with a staff member. And we, at AEquitas, we analyzed the nation's rape and sexual assault laws, and we actually found that 39 states, plus the District of Columbia, Puerto Rico, and the Virgin Islands, as well as federal law, have statutes that specifically, per se, bar an individual's capacity to consent when the offender is a corrections officer. So that means that the other 11 states do not specifically have statutes that address or include a corrections officer, but those other jurisdictions could include those officers through other provisions. So just because they're not specifically pulling out and saying corrections officers does not mean that those persons are not included. Our understanding is that all states bar this kind of sexual contact. Christina, did anybody indicate any additional comments or questions?
Not as of yet, but I would definitely encourage you all. I know that I was a little slow to respond to some initial private chats when the webinar first got started, but it's definitely easier for me to respond at this point. So I would again encourage you all to send me even comments, questions, any input that you might have for myself or Vicki.
And also, in terms of this, what do we always want to be arguing in terms of common sense? That consent is something that always has to be determined on a case-by-case basis, no matter what the history is, what the relationship is. And certainly we know this if we look at one of the most sacred relationships that we know, and that is spouses. Certainly a spouse has to consent each and every time there is any kind of sexual contact. And so even this defense argument here that there could be a pattern of conduct, or that the consent, in other cases we certainly hear that the consent could be somehow implied based on a pattern of conduct. And we really need to be not only making of course, are sound legal arguments when we're responding to these defense motions, but we want to be responding and reminding everybody who is part of the criminal justice process that we need to be using our common sense at all times throughout this process, and that consent must be given in every single encounter. A little bit more on rape shield, and specifically in terms of piercing the rape shield. So these are some examples of exceptions, examples of when the defense might be able to pierce rape shield. And please note that they're pretty specific. The exceptions are in three categories. The first is to be able to prove the source of semen, injury, or other physical evidence. So this could happen in a situation where, for example, a girlfriend was with her boyfriend, they had consensual sex, she went home and was raped by somebody in her home. And therefore, when they did a rape kit, there would be another source of semen. Another example would be to prove consent, and another example would be it's constitutionally required evidence. If anybody has questions about rape shield, we have done comprehensive research on rape shield, and if you contact us at AEquitas, we'd be happy to share that with you. Please note that all of the exceptions here are, of course, subject to a specific jurisdiction's rules of evidence. And again, B, to prove consent, that second one, would not apply here in our case because consent is per se prohibited when the defendant is a staff member. One other thing I want to share in terms of rape shield is the third provision, C, which is the procedure to determine admissibility. This rule actually says if the defense is going to pierce, it must file a motion. So this is a very important argument for us as prosecutors to make. You know, Your Honor, this is not something that can come in at all. First of all, it's protected by rape shield. And second of all, the rape shield statute includes a requirement that if a party intends to offer evidence under Rule 412, the party must file a motion and state the purpose for which it's offering the evidence. So basically what this is saying is that the defense, if it's going to argue one of the provisions in B, proving the source of semen or injury, proving consent, or it's constitutionally required, they have to file a motion. However, how many of us have found ourselves to be at trial only to have defense bring in something that perhaps we had never even heard of? And here we are in the middle of trial. So this goes back to preparation. You've got to spend a lot of time talking to your victim and ask, you know, is there anything that I need to know? Part of my job is to protect and support you through this process, and explain. I file motions to keep irrelevant information out of court, away from trial, because a lot of times, especially in cases where a staff member might have access to an inmate's records, that staff member, and certainly in cases that are involving acquaintances or family members, might know things about what occurred in the victim's past that they might choose to try to bring up at trial, and that you as a prosecutor won't know about unless you spend a lot of time during preparation talking to the victim. So in terms of Sixth Amendment implications, we want to consider these throughout. And Sixth Amendment is the Confrontation Clause. Essentially it says the defendant in a criminal case has a right to confront and cross-examine witnesses against him or her, and the defendant is permitted to introduce relevant material and admissible evidence. The leading case in terms of how the Sixth Amendment, specifically in terms of confrontation, applies to trials now is the 2004 case of Crawford v. Washington. And essentially what Crawford held was that when a witness cannot testify, and here a witness in the state of Washington could not testify due to that state's marital privilege law. And in Crawford, the state went ahead and introduced that witness's recorded statement that was made during police questioning. Because that statement was considered testimonial, only confrontation will satisfy, meaning that statements that aren't given during an ongoing emergency and statements that are given in contemplation for use at a later criminal proceeding are considered testimonial and are thus subject to confrontation, meaning the witness will pretty much have to testify unless the witness is unavailable and there is a prior opportunity to cross-examine. I realize that for many of us, Crawford v. Washington and all of its case law, all of its progeny, can be very, very confusing in terms of analyzing which statements are testimonial and non-testimonial, which should come in and which shouldn't. And we especially have to consider these throughout our preparation because for these cases, we are investigating and we are prosecuting under evidence base. So we really need to have an understanding of Crawford v. Washington in these cases. In the next PREA webinar that we give, and certainly the last, we're going to give 2 more, we're going to talk much more about Crawford and related Sixth Amendment cases. Those webinars are going to be coming up in the middle of this year, and hopefully you will join us for those as well. So the balancing test is always an important analysis. What does it say? Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. In the context of Rape Shield, there are some instances where courts have found that the probative value of victim's sexual history outweighed the prejudice that it posed to the victim. So again, the defense will lightly argue that the relevancy test centers on whether the victim's sexual history with other persons indicates a likelihood of consent to the act in question. So again, if you're dealing with a case where the offender is another inmate, you will have to consider this more carefully. But as we just discussed, the practical application by the courts is less lenient in terms of admission. Let's move on to our next category, offender-focused motions. And these would apply whether an offender is inmate or whether an offender is staff member. We have other bad acts, 404B, so any relevant prison history of the offender, consciousness of guilt, and admissions made by the defendant. Another category I want to mention that isn't on the slide is considering gang or organized crime charging and sentencing enhancements. And I didn't include it on the slide because we don't often see cases that involve gang members. They certainly do happen, but they're not coming up as often as we would think. And I just wanted to mention it so that you think a little bit more about it, and if the cases do come up, you probably have in your office, or hopefully you do in your jurisdiction, whether it's in your office or whether in one of the police precincts, a gang expert, somebody who works specifically on gang cases in your jurisdiction. You want to take some time and talk to that person about the gangs in the area, about gangs with which the offender or your victim, frankly, but most likely the offender would have been affiliated. And separately, it's important to talk to the prison's gang officer or gang expert. It might not be a person whose title or his designation is written down somewhere. In other words, you're not going to be able to do a Google search and find out who the prison's gang expert or the prison's gang officer is. But if you talk to your investigator and you talk to the other staff members in the facility, you certainly could find the person who is an expert on the gangs that are inside the prison and outside of the prison. And sometimes they're very separate, and sometimes they're very similar. Sometimes they're one and the same. But you won't know that, and you certainly should never assume that unless you talk to these experts. So 404B, other bad acts. We've mentioned this a little bit already, and I want to take some time to talk about it a little bit more. Sometimes people refer to 404B as prior bad acts, but it's really important for us to remember that we're talking about other bad acts. So they don't necessarily have had to occur prior to the incident that is part of your case. But again, this depends on your jurisdiction's case law. So what do we mean when we say other crimes, wrongs, or acts? We're focusing on the offender, and we mean evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show that the person acted in conformity therewith. So we can't admit a defendant's other crimes or bad acts to show that he acted in conformity with a character trait, to show that he's a bad guy, however, or a bad girl. We could admit the evidence for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. That's a lot of categories for us to be able to work with. So let's talk a little bit about Mary Bennett. What do we already know about her based on the information that James Minor disclosed to his teacher? We know that there probably are at least 2 other victims, and we know that these are just the victims that James Minor may know of. So James Minor himself knows of at least possibly 2 other victims. So what do we know about rapists in general? There hasn't been specifically research done about serial rapists inside of jail, but we know about this research of rapists in the community outside. And the research has shown that the majority of rapists are serial offenders. They commit multiple rapes over time. So we, along with authorities, want to investigate the possibility of victims both in and out of confinement. These are Mary Bennett victims, both in and out of confinement. We want to look into Mary Bennett's history. What did she do prior to working in that confinement facility? How long had she been working in that facility? What other facilities did she work in? If she was transferred, why? And we shouldn't just look at records. We want to talk to people. And we want to look at what else she does. Is she only working in confinement facilities? Is she perhaps teaching classes somewhere? Is she in charge of children in other professional capacities? Has she acted in a similar manner, doing these other jobs, or perhaps volunteering somewhere? And what do we know about predators? We know that sometimes they do things so that they can have access to victims. So we really want to take a look at Mary Bennett and gather as much evidence as we possibly can. Other important rules of evidence. Number 1, Rule 413, evidence of similar crimes in sexual assault cases. In a criminal case in which the defendant is accused of an offense of sexual assault, evidence of the defendant's commission of another offense of sexual assault is admissible and may be considered for its bearing on any matter to which it is relevant. And number 2, Federal Rules of Evidence 414, similar crimes in child molestation cases. In a criminal case in which a defendant is accused of child molestation, the court may admit evidence that the defendant committed any other child molestation act. The evidence may be considered on any matter to which it is relevant. So we certainly want to compare admissibility under 404B to that under 413 and 414. And really our admissibility analysis, what center on a few questions. Is it offered for a proper purpose under the rule? Is it relevant? Is it unfairly prejudicial? But remember, under 404B, an improper purpose is to show action in conformity with a character trait. So we want to look at those 8 or 9 examples of ways for admissibility under 404B and focus on all of them. Make as many arguments as you possibly can. Consciousness of guilt. This is an example of something we often may have evidence of, but some of us feel very nervous or hesitant about using. We're really not sure what to do with this kind of evidence. Generally, we can use consciousness of guilt as evidenced by, for example, flight, concealment, use of an alias, threatening or tampering with a witness or a juror, and here, of course, we're talking about intimidation, and false exculpatory statements. We're thinking about jury instructions. So a jury instruction regarding consciousness of guilt might tell jurors that they could consider that conduct, that consciousness of guilt conduct, along with all other evidence in deciding whether the prosecution proved beyond a reasonable doubt that Mary Bennett committed the offenses charged. So generally, courts determine admissibility by analyzing, again, whether the risk of unfair prejudice substantially outweighs the fair probative value, and that's under Rule 403, or whether the other act or crime evidence is probative for a purpose other than proof of character, and that's 404B. A very helpful resource and reference here we included on the slide, Weinstein's federal evidence. Weinstein's is helpful not only if you're dealing with federal rules, but has a lot of helpful information that apply to state rules of evidence. So res gesta, I just want to talk a minute. What do we mean by that? Because this is a term that we all learned in law school and then we kind of forgot about because it's not really found in the federal rules of evidence. And it's sort of been displaced by other hearsay exceptions. But it really is a hearsay exception, and it refers to the entire period of the commission of a felony. So it's really the start to finish of a felony. It's the events, it's the facts that are part of the sequence of events that are necessary for us to view and define the actions and the crime that we're currently considering. So perhaps if Mary Bennett changed James Meyer's attendance records or other records to indicate that he was somewhere other than with her during the time that she was raping him, that would be an example of res gestae. They're words or phrases that form part of or explain a physical act, or they're statements or explanations that are so spontaneous that they really couldn't be fabricated. And they're statements that are evidence of someone's state of mind. So if we found that Mary Bennett had changed attendance records or other records, class records, we could certainly argue that that's part of her state of mind, that she knew she had to cover something up, that these actions were part of a consciousness of guilt. The defendant's statements, another thing that in cases involving a staff member, so when we're talking about these particular sets of facts, can be very, very difficult. And perhaps not at first glance would we understand this, but when we contemplate the Garrity versus New Jersey case, we get a full understanding of the real investigative complexities that we would have in a case involving a staff member's sexual abuse of an inmate. So what is the Garrity rule or the warning? Really, it is that employees cannot be given the choice of incriminating themselves or losing their jobs. That's what it comes down to. It comes down to you can't compel somebody to make a statement, because if you do, those statements, those confessions are going to be considered involuntary. So for Mary Bennett, if we're getting, as prosecutors, a statement, we need to ask under what circumstances did she give that statement? Did she give it to her employer? Was she given warnings? Did she give it to investigators? And if so, and I'm talking about law enforcement investigators, if so, was that before or after she had talked to her employer? Where was her employer at the time? So for interrogations of suspects who are corrections employees, law enforcement should carefully consider the implications of Garrity versus New Jersey. So not only when they're preparing for questioning, but also in terms of avoiding the use of information that was obtained as the fruit of a coerced or otherwise improper employer-employee interview. So if in our case Mary Bennett gave a full confession to her supervisor at work, and when the law enforcement detective showed up in a confinement facility and the supervisor shared some information with the law enforcement detective, and that detective used that information during the interview with Mary Bennett, we might have a serious admissibility trial problem under Garrity. Serious problem. So Garrity really held, it was a case involving police officers, and it held that where police officers being investigated were given the choice either to incriminate themselves or to forfeit their jobs, and the officers chose to make those confessions. The confessions were not voluntary, but they were coerced, and the 14th Amendment prohibited their use in the subsequent related criminal prosecution of the officers in state court. Garrity resulted in the requirement that a public employer provide a Miranda-type warning when interviewing employees in these kinds of situations. And the failure to provide that kind of warning could, as we said, result in the statements being considered in violation of the suspects, of the defendant's Fifth Amendment right against self-incrimination. And I'm just curious, I don't know if you guys could use the hand raise option. Can you just raise your hand if you have had a case like this? I can tell you I did have a case once involving a college professor who was not given Garrity warnings and who had committed an act of sexual abuse against a student. And I had a lot of problems at trial because of that statement, and of course I couldn't use that statement. There were no Garrity warnings given. Has anyone else here had a case involving a Garrity issue, perhaps where they got a statement from an employer with a confession, but they couldn't use it? If you have, I'd be interested in hearing that. Just click the hand if you've had it, or click yes on feedback if Christina could put that up, whatever's easiest.
I did open up the feedback window, and it appears that actually one individual has had a case similar to that, Vicki, but the rest either did not answer or indicated that they had not.
Yeah, and for that person, if you want, I mean, definitely we'd be interested in hearing what happened in your case. If you want to type that to Christina, and of course anonymously she'll share. I can tell you in my case, the statement from the employer was tossed. I luckily didn't have a problem with the law enforcement statement because they did not know about the statement from the employer at the time law enforcement took a statement from the defendant. But the confession was in the statement to the employer. It was not in the statement to law enforcement. So what we initially thought was great evidence in a case ended up not being usable at all because there had not been Garrity warnings. So take your time if you want to share that. It would be really interesting, I think, for us to hear what happened in your case, what the situation was. But in the meantime, we will continue with our case. So Mary Bennett is informed of the allegations. She's informed of the report. And she is informed that there is an investigation underway. Mary Bennett is told by her supervisor that she should go home for the day and she is going to be placed on administrative leave. Before she leaves the building, before she leaves the confinement facility, Mary Bennett sees the facility chaplain in the hallway, and the chaplain asks her if everything is okay. She says no, and she hopes God will forgive her. Is Mary Bennett's statement to the chaplain admissible at trial? So please use the feedback option and tell us yes or no.
Okay, guys, the feedback window has been expanded for all of you again, and the questions are coming in slowly, or the answers are coming in slowly but surely. And I also wanted to let you, Vicki, know, and everyone listening, that the individual attending the webinar who had the case or has the case, it's actually still an ongoing case, so she's limited in the information that she can share. But I have asked her to keep us up to date on the end result, and
we wish her luck because that's a tricky issue to have. So good luck. I wish I had some great case law for you from my case, but unfortunately I don't.
Well, and maybe we'll do some good case law that comes out of this. So that's why I think keeping in touch with everyone and finding out what happens in these cases that don't happen or don't take place as often is helpful for us and for the prosecutors that we serve. So thank you all for sharing that information with us. And in terms of the feedback question, it looks like it's split right down the middle with just a few more yeses than nos. So Vicki, you want to?
So thank you for responding. So first we really want to ask, is this an admission? So on what basis would we be seeking to admit this statement? What would we be arguing? Is this consciousness of guilt? Is this an admission of guilt? And if yes, is there some rule that would then prevent it from coming in? So let's look at the facts. I mean, she was perhaps on or off duty. We don't know. At the time that she made the statement, was she on or off duty? And is that even an important factor in the analysis? She technically was still employed. She made the statement to a chaplain, but she made it in a public place. There was no private room. She was in a public place. She was in a hallway where anybody else could have heard it. Did they have a history, a relationship? Did she regularly go to the chaplain, and in what capacity? Did they have a relationship of confidence? So in terms of thinking about what an admission is, we would look at Rule of Evidence 801D2. And we would specifically look at 801D2A, the very first provision, which is the statements made by the party in an individual capacity. So you certainly would want to analyze all of these things, and then you would, of course, want to analyze your statute's confidentiality and privilege rules, and we're going to talk about those a little bit more in 2 slides. But the first part of your analysis would be, is this an admission? And I certainly would argue, yes, it certainly evidences consciousness of guilt. Now, of course, we know what the defense is going to argue. She was having a bad day, or she was referencing something else, a previous conversation that she had had with the chaplain, something. But, you know, you would argue common sense. This is, of course, what she's talking about. She had just had a conversation with her supervisor, and you would want to argue it's an admission. Charging and sentencing enhancements. We want to file any mandatories or enhancements in writing as soon as we get the case. Because perhaps if there's a mandatory minimum attached to, for example, her position of authority or something else, they could absolutely be helpful in structuring a plea. So if the defendant sees that you're going to move for an enhancement or a mandatory minimum, she might voluntarily enter into a guilty plea. But we want to file notice of mandatories and enhancements in writing within a certain time period, and be prepared to accompany these things by sworn testimony at trial. I'm not sure how many of you had issues, but I know, for example, in narcotics cases, when we're talking about the sentencing enhancements, which in some jurisdictions occur at the time of charging, that you can have an enhancement if narcotics were dealt within 1,000 feet of a school. And usually it's not enough for you to have somebody testify, show a map, and testify that the corner was located within 1,000 feet. You usually need to go many steps further and get somebody to come in and testify that the school was actually operational on the date of the narcotics transaction, et cetera, et cetera. We can't take anything for granted in terms of these mandatories and these enhancements. Dot all the I's, cross all the T's. Records-related motions. These take a lot of time for us to prep, and they're both records and witness protection motions. So when we talk about non-disclosure of identifying information, and we talk about motions to exclude certain records, and we're talking about psychological records, school records, human services and child protective services records, we could also include certain portions of medical, prison, and other records. So, of course, we want to redact these when appropriate, pay attention to the rules regarding the prosecution ability to redact versus the necessity of redacting in camera. And, of course, never take for granted that the defense will properly redact information if it gets a hold of those records. So do whatever we can to protect, because if the defense attorney gets that information, so does the defendant. And let's talk about the difference between privacy, privilege, and confidentiality, because these are things that often are not clearly explained to us and can be difficult to understand. So the right of privacy is generally the right of a person to be free from public scrutiny or public exposure that's unwarranted. And when we think about privacy, we think about things that they're secret. These are things that are secret. And that privacy umbrella includes confidential information and privileged information. So confidential information is something that ethically and legally a professional has a duty to a client or patient to keep safe. So confidential information is that which is legally protected from forced disclosure. Privileged information, a privilege, is a legal right that gives both the sharer and the holder of information special protection in a court of law. So the sharer and the holder could refuse to disclose certain communications in a privileged relationship. And some examples are an advocate-client, a doctor-patient. There's a spousal privilege, which we talked a little bit about previously in the Crawford v. Washington case, and an attorney-client privilege. And the privilege is information that cannot be disclosed in court. There cannot be compelled disclosure in court. And what we want to focus on when we're thinking about these communications and the professional relationships is, what is the justification for protecting the information? In other words, what's the justification for those confidential communications? Really, the justification is we want people to have these relationships with the professionals so that they can get help throughout their everyday lives, right? However, what would we argue in the case of Mary Bennett and what she said in the hallway? That at the time she said it, she wasn't engaged in that relationship. You know, she wasn't seeking help. She wasn't seeking counsel. She was walking down the hallway on her way out of the building. So certainly when we think about the justification, and this would be something that I would absolutely say you'd want to point out to the finder of fact. You want to point out to the judge if you're arguing this motion. The justification for these confidential communications is to uphold the sanctity of the relationship, to consider how much they help people, to consider why we allow for these confidential, these secret communications with certain professionals. And at the time that Mary Bennett made that statement, she wasn't engaged in the relationship. She was in the hall. More on privacy, confidentiality, and privilege. A sexual assault survivor really said it best, that confidentiality is critical to the survivor's comfort level. The more education there is given to the public about the strict enforcement of confidentiality, the more survivors will come forward. This is a reminder to us not only to protect the sanctity of confidentiality, to fight for our victims' ability to keep some information confidential throughout the criminal justice process, but for us to explain the rules and the laws to a victim, because victims will not come forward if they think that a lot of their statements, a lot of their history will not be confidential. So for all of us throughout the criminal justice process, let's take some extra time to explain the differences to our victims. And I want to note specifically about PREA that the Prison Rape Elimination Act does not require that a victim participate in the investigation or the criminal justice process. So a victim can disclose but need not participate in the process. The agency will still investigate while trying to uphold confidentiality. Motions related to trial. There's, of course, we want to file a motion to compel reciprocal discovery. We want to specify that the defense should have to disclose and provide this information by a certain date, and that there be repercussions if they don't. We want to file motions regarding our prompt complaint witness. And here, we know of Gloria Velasquez, but there might be other persons that James Minor told. And we also want to note that in some jurisdictions, the timing of the disclosure is a factor. So in some jurisdictions, because James did not tell for a certain period of time, Gloria would not be considered a prompt complaint witness. And her statement, James's statement to her, wouldn't be admissible under that exception. Tender years we're going to talk about a little bit more in a minute. Support dog, and this is an example of something else that you could file that you could certainly use to provide support to a victim who needs it in court. And this could be really for anybody, but particularly for a juvenile or somebody who is a little older or elderly later in life, or someone developmentally disabled. And there are certainly examples of this happening in many, many jurisdictions across the country. Hearsay statements, of course, we mean excited utterances, statements for the purpose of medical diagnosis and treatment, and others. res gesti we talked about, but I also want to say, you know, there's an example within the last year, within the last few months, involving the sexual abuse case with the Archdiocese in Philadelphia, Monsignor Lynn, that the prosecution introduced all of the evidence surrounding the years of abuse that some of the victims had endured by submitting a motion to introduce this evidence under res gesti. So they submitted a motion because they explained that without this evidence, they could not be able to explain, and no one would be able to understand the full context of the crime, the offender behaviors, the environment in which this was able to continue unchecked for such a long period of time. Expert testimony, we're going to also talk about a little bit in a couple slides. Courtroom, you want to talk about and consider layout, closed-circuit television. Certainly you want to consider this if intimidation is a factor. The behavior and the position of the defendant. I once had a case where a defendant wanted to hold a Bible on the table in front of him throughout the duration of the trial, so I held a hearing. I litigated a motion to say that he couldn't do that. Exclusion of certain persons from the courtroom if there has been intimidation. Now, of course, we know courtrooms are public places, so for the most part, unless there's intimidation, you can't require somebody to leave a courtroom. However, to make a victim more comfortable, you certainly could ask the judge to ask persons who really don't need to be in the court to step outside for a certain period of time and stress that they're entitled to be there, they can remain, but, you know, really for the next hour, 2 hours, could they step outside. And finally, forfeiture by wrongdoing, which we're going to talk about in our last webinar that we deliver with the PREA Resource Center. Forfeiture by wrongdoing is directly related to what we've already mentioned, the Sixth Amendment and Crawford line of cases, as well as Federal Rule of Evidence 804b6. Tender years. Tender years is a hearsay exception that allows the prosecution to admit, in certain circumstances, out-of-court statements made by children under a certain age at the time of the proceeding concerning acts or crimes involving child sexual abuse if there are certain indicia of reliability and the child testifies at trial or the child is unavailable and there's other corroborative evidence. And the unavailability could be due to several reasons. The one thing I wanted to note is that there has, since 2004, been a caveat attached to tender years, and that is there have been some jurisdictions in which tender years has been challenged on Crawford grounds, and that case law is evolving. So if you are dealing with a sexual assault case or other case where you're dealing with tender years and your witness is unavailable, I highly suggest you do some research in terms of Crawford implications, and certainly you can reach out to AEquitas. We'd be happy to help you with that analysis. Expert testimony. This could be on a number of different subjects. Victim behavior, on the culture of confinement and prisons and gangs, which we talked a little bit about earlier. Medical, including sexual assault anatomy and the sexual assault forensic examination itself. And DNA. So as far as victim behavior, you certainly want to determine and include in your motion the relevance, what the behaviors are, that if it's scientifically accepted because it's beyond the ken and understanding of a layperson, who should testify and about what. These are all things you want to consider. Medical, determine whether a sexual assault nurse examiner or doctor, the person who examined the victim, should also be qualified and or be your sole expert, or whether you want to get an additional medical expert. And finally, it's really important to consider under DNA is to remember the two main cases that have come out over the last few years, and that is Bull Cumming v. New Mexico and Melendez-Diaz. And essentially what they've told us is that we want to be careful about who is testifying. Bull Cumming held that the Confrontation Clause, again we're talking about the Sixth Amendment, prohibits the government from introducing a lab report, a forensic lab report, through the testimony of an analyst who did not sign the certification or who did not personally perform or observe the testing. This is all about hearsay and confrontation. And then Melendez-Diaz versus Massachusetts which is pretty similar, prohibited the introduction of a laboratory drug affidavit without the in-court testimony of the lab technician who certified the report. Very, very similar. Throughout all of this, we've got to be considering our Sixth Amendment implications and repercussions. So in summary, I just want us all to try to keep in mind that we don't work alone on these cases, that these are cases where if we're really going to be able to support victims throughout the entire process, and if we're going to be able to hold defenders accountable, we need to be working together. Let's plan ahead, file motions whenever possible, hold as many hearings as possible prior to trial. Be creative but be precise. If the defense is going to try to introduce this stuff, then make them follow the rules and put everything possible on the record so that you have created a good record, so that if and when the defense appeals, you have all of these things already litigated to support upholding the conviction. And finally, do your research. Get as much information as you can and put it in your brief so that the court can comfortably rule in your favor. No judge wants his or her ruling to be appealed. So do what you can. Be aggressive and be comprehensive, but be realistic so that you're not creating good case law. You're not creating bad case law. You always want to create good case law. Here are some additional resources. I think that Christina might be able to mention a little bit more. And then also, please let us know, we have a few minutes left, if there are any questions.
Thanks, Vicki. And again, if you all do have any questions, please go ahead and submit them. I just wanted to say thanks to Vicki for presenting today's webinar, and also thanks to Tara Graham from the PRC for making herself available for any PRC-related questions that you all may have. There are a wealth of resources available through AEquitas and the other partners at the PRC. I would encourage you to reach out to us on these cases. We know they're tough cases and they're not always the most popular, but they're important. And we just want to thank everyone on the call for your dedication to increasing victim safety and offender accountability in your communities and in your confinement facilities across the country. And just remember that we're here to support you in the work that you do, and we appreciate it so very much. Following the webinar, you will receive you will receive an email from AEquitas, including a handout version of the PowerPoint presentation that Vicki worked from today, along with her biography, so that you're able to apply for continuing legal education credits. Also, you'll be directed to a SurveyMonkey link, which earlier today was not working, so we may need to send a separate email, but that link will allow you to evaluate today's webinar. And just on behalf of AEquitas and the PRC, I want to thank you again for participating in today's webinar, and remind you that we're available to assist you with any technical assistance or training needs you may have 24/7. Vicki, did you have anything else to add?
Just thank you. And that you can call or email us anytime. You can call or email me directly anytime if you have any additional questions.
Great. Thank you all so much. Have a great rest of the week and weekend, and we look forward to you joining us on our next webinar. Bye-bye.